Hi, everyone. Welcome back to another episode of Capitalize on Retirement. Today, Brandon and I are joined with special guest, good friend of ours, attorney Rick DeBlasio. And today we're going to talk about all things estate planning, some of the most commonly asked questions that we get. So, Rick, hopefully you're ready. We're going to bounce some questions off you.
Going to have a fun topic today, right? What happens to your properties when you pass away?
I will say Rick's probably, we've had some good guests on, but I think Rick might be the smartest.
Yeah. Oh, yeah. I don't know about competition might be low, though.
Right.
Yeah.
Competition's low.
Bar might be set a little low.
Bar set low. So today will be fun. We're excited to go through this. Brandon, you want to kick us off with one of the most common ones?
Yeah. So, Rick, we have clients all across the country, but we're located, our main locations are in PA. So a lot of the questions that we get are around Pennsylvania. And we wanted to know what will actually happen in Pennsylvania if you die without a will.
Yeah, so if you pass away without a will in Pennsylvania, in any state in general, there's what happens is the state comes in through a statute that's passed by a Pennsylvania legislature, any state's legislature, and they actually determine where your property goes. So essentially the government comes in and says, well, you passed away without a will. Here's what the statute says, and here's where it's going. Typically it is a next of kin if that's available. So if you pass away and you have children, your children would inherit in equal shares, and it goes down the line all the way down to first and second cousins. Typically, as you know, we typically don't recommend dying without a will because I know that I don't want the government and courts telling me what's going to happen with my property when I'm no longer here.
And there's obviously some simple things that you can use so that doesn't happen. One, and we see this way too often from Brandon and I's end, or just naming beneficiaries on contractual accounts, on your IRAs, on your TODs.
Yep.
Obviously, then we see a lot of people don't have wills and things like that, which is another issue.
Yeah, and I mean, I can't tell you how many times when we're reviewing someone's accounts, they have an old 401k and their ex-wife is listed as beneficiary on that account, right? And so even if someone does have a will that says, hey, I want my kids to get my accounts, well, if you have your ex-wife on that 401k as beneficiary, that trumps the will, right?
Exactly. Any type of document or account that has a beneficiary designation is actually considered outside of your estate, and that beneficiary designation controls. So what we do, I mean, we talk about this all the time. When I meet with my clients and we're going over potential wills and trusts, et cetera, I say, now's a good time to get with the folks at Capital A or whoever is the custodian of those documents and make sure that those beneficiary designations are up to date.
Right.
Yep.
And I think that's a big thing.
I think that's one of the best things that you've done for our clients, Rick. Like, I can't tell you how many times we see estate planning attorneys and they draft the documents, but then they never tell them how to fund those trusts or whatever it may be that they're establishing.
Right.
I see it all the time.
And oftentimes the documents that you guys may be custodians of, and those accounts are actually worth more than what the estate is, more often than not.
Yeah, we see that often. I think the one thing that you said that's really important that most people miss is your contractual accounts, your beneficiaries on your IRAs, your TODs, right, whatever assets you have, those proceed your will in passing. You said it's outside of the estate, but those, like I'll see it, well, I have my will, and my will says this, and I'm like, but your beneficiary documents do not.
Right.
And I think it's important for, everybody listening to understand that whatever's on your beneficiary document is going to happen.
Exactly. And there's no way around it. To your point, it's a contractual obligation, right?
Yes.
No one's going to be able to change that under any circumstance. So, again, if you're getting into estate planning or even just how you guys do the quarterly meetings and things like that, it's always a good time just to make sure those types of accounts are up to date and the correct beneficiary is designated.
No, I agree.
I think that's why it's important to have advisors, attorneys working together on these things, right? I mean, if you don't have a team approach, there could be somebody missing the ball.
Oh, yeah, and we talk about this all the time, right? You have wealth management, you have estate planning, and tax planning. And although they're kind of three separate universes, they better all be rowing in the right direction to really maximize yours and your beneficiaries' accounts and what people are going to inherit when that time comes.
Yep, and that's why I think, a lot of people are familiar with Brett, our CPA, Brett, the CPAs in our office. A lot of people have met with you. So I think, couldn't agree more. The coordinated approach is so meaningful to the people that we serve. It's valuable to us because we have a question on something regarding their estate plan. We could reach out to you and vice versa for the client. So, it is really beneficial there.
It works out great. What you guys do from that totality standpoint of making sure that your clients are protected from all those realms that we've just talked about is great, obviously.
Yeah, and I think, I'm sure the listeners, one of their main questions is going to be about trust, right? And so let's kind of dive into, what's the difference between a will and a trust? And I know this, Rick, and I know you're going to dive into it. A will actually is going to guarantee probate. Right?
Yeah.
So how do we actually avoid probate and maybe get into what actually the probate process is in Pennsylvania?
Right. So that's kind of the big thing, right? A will is a very simple document. It's who's going to get my assets in my estate when I pass away and who's going to be in charge of making sure those assets get where they go. Now, a lot of people think that, well, I have a will, I don't need to go through probate. Well, that's not true. In Pennsylvania, you actually need court approval. Your executor or executrix, if it's a woman, will need court approval to open up the estate and go through that probate process, which, again, could take 6 to 12 months. And that's if you have a will. If you have what we call a revocable trust or an irrevocable trust, which I'm sure we'll get into a little bit later, and that might take 4 podcasts to do. But a revocable trust is basically a contract between a grantor, so the person that is giving the property to the trust, the trustee, the person that's going to manage that trust and those assets in the trust, and the beneficiaries. Now, the good thing about what us attorneys have done through time is create this document called a revocable living trust. It's a very flexible document. And so what it states is that you could be both or all three, the grantor, the person that's giving the property to the trust. You can be the beneficiary, so you can use those benefits during your lifetime, and you can manage them and be the trustee. And I would tell you that a lot of people, probably a majority of people, should use a revocable living trust during their lifetime. You avoid probate, so when you pass away, that is basically a contract between the trustee that you appoint, the alternative trustee, and then those beneficiaries, whomever that may be. And again, you're saving the time and hassle of the probate process. I will say in Pennsylvania, compared to other states, the probate process isn't as difficult, but it is certainly cumbersome, especially on the executor, executrix, and it takes time. So we typically do like to go the revocable living trust route if it makes sense for the client.
Okay. And I guess in terms of maybe cost, let's just talk about not necessarily cost of what it takes to draft those documents,
Right.
but if somebody is going to go through probate, I know that can sometimes be expensive, and I don't know if you have a dollar value or what that could potentially be, and what that can maybe save you on the back end with the trust, because the trust might help avoid probate versus actually having to pay it. And it is more expensive up front to draft them.
Well,
It is.
I'm going to piggyback off of that question because that's a great question. So one of the most common questions we get is, should I put my house in a trust or should that go through a will, right? Because your investment accounts, as long as you have your beneficiaries listed, are going to be outside of that will.
Yep.
So let's use a house. Let's say that I have a $500,000 house and I know that I want that house to go to my beneficiaries, right? My daughter
Yep.
right now. So if I were to settle that through probate, rough estimate in Pennsylvania, what's going to be the cost of probate in that situation on a $500,000 house? And I already know where it's going.
Right. You're talking anywhere. You're talking 3 to 10% basically. And that's
Okay.
just probate fees. That's not court costs. That's not the time that it takes to go through this process. And if there's any type of lien or encumbrance on that house, you're really, kind of having to pay that off, right?
Mm-hmm.
And then you're having to look at that. So with the trust, you avoid all that. Yeah, selfishly you pay an attorney a little bit of money up front,
Yeah.
but there is no probate process or probate fees. There's no court costs, et cetera, in dealing with that once the time comes where the grantor passes away.
So it's a more seamless transfer of asset by having the trust. It's also, let's just say $500,000 house passes through probate. Let's say it's 5%. That's $25,000. Now I know this, but it costs a whole lot less to set up a trust on the front end than that.
Oh yeah, easily, especially if the trust is straightforward. And if it's not a straightforward trust and it is a little bit more, you're still going to save money in the long run because you're going to save money on those other assets that would avoid probate.
Yes, that makes sense to me.
Yeah, definitely. I think we get that question almost all the time. So why don't we talk about, because it sounds like, with the trust, it makes a lot of sense, right? So let's talk about maybe the downsides of it. I guess one of the downsides would be it's a little bit more expensive up front to draft that trust. But what are maybe some of the other things that you could maybe think of?
There's not a whole lot. Again, the upfront cost is significant, and you have to look at each individual client's situation and whether it makes sense for them to go into a trust. Again, in Pennsylvania, the probate process isn't cumbersome, so it may make more sense for them to just kind of move forward in the probate process. Maybe the estate's not a big estate. Maybe instead of a $500,000 house, we're only talking about a $100,000 house, or a small estate, $50,000 or less, and then it's a really streamless process. So, I guess to answer your question, I'm going to give you the attorney answer. Right? It depends on that specific client situation, and you go through that by working with the wealth management folks, by the tax folks, and the attorney all together.
And one thing on probate, because this is probate is public, correct?
It's public record. It's in the courts.
Where a trust, if it goes through a trust, it's not public, correct? It's not a matter of public record.
Exactly. So probate is public record. It's a court situation, so that everyone kind of knows the value of your estate when you pass away. But a trust, I liken it more to a private contract, right, between the grantor, trustee, and the beneficiary. So that does not become public, and it transfers immediately, right? That's the nice thing. The assets that are in that trust account, if it's the house, if it's a financial account, et cetera, those pass immediately, essentially.
Well, which is really nice. I have one other distinguishable item, I guess, on wills versus trust. So I think the other thing, a lot of people will tell us as we're meeting with these families, hey, I want to make sure my kids receive this money, but I don't want them to receive it all at once.
Of course, right.
Right? That's a very common question. And a lot of people will say, well, I have that in my will. But again, we just mentioned that beneficiary document. So first question I'm going to ask, if you have it in your will that your kids can only receive money over 5 years, 10 years, or for health, education, maintenance, whatever, that will not be valid.
That's
correct?
not going to hold up. So a will, basically what's going to happen is you go through the probate process, the courts and your attorney come up with what the estate is worth, and let's say you have 2 children and they're each going to get equal shares. They're entitled to 50% of that estate immediately, as soon as the court approves it.
Doesn't matter whatever else is.
Doesn't matter what the will says. They have no control over that. With the trust, and we've used this term a bunch, control from the grave.
Yep.
After you pass away, that trust can say, well, I only want each child to receive $5,000 a month until their share runs out.
Yep.
Right? The trust that has to be upheld. Will, that does not include that. It can't happen.
Yeah, and just on that topic, I know these are client-specific scenarios, but I had a client maybe a year ago that told me, hey, I'm a little worried about a divorce from one of my kids. And so, that's not something that everybody's worried about, but some of our clients are. And so, trusts are the only way, from my understanding, you would know better than I would, that you can control some of that, right?
Exactly, yeah. So if you have a will and let's say you come from a blended family, right? Stepchildren involved, et cetera. Typically, people want to leave their assets to their spouse in 100% whole interest. Well, if you have a will, there's nothing stopping from your spouse from disinheriting your children from your previous marriage, if that's the case. So we do that a lot with blended families, the revocable living trust, to make sure that all the children are protected, whether it be from a previous marriage or your current marriage with your spouse now. And I think that's a big part of trust and what we get into. And I know we're going to get into this later on, but that's one of the scenarios where we think about making the trust a contingent beneficiary on an IRA account.
Yep.
And it's limited to when we do that, but that's one of the situations we look at that. And that's when you and I or whoever the wealth management folks are at the time need to have that discussion with the client to make sure they understand what's appropriate at that time.
No, that's great. I love it. I think there's a lot of things we could talk about with the revocable trust. So let's just talk about the other side of that. And let's dive into the irrevocable trust. And we can keep this very high level, Rick, but if you could just give us like a baseline of what is an irrevocable trust, and then maybe just some of the differences, just a couple, because I know there's a bunch of options.
You don't want to keep everyone here for a couple hours. So basically the way that I like to kind of differentiate a revocable trust from an irrevocable trust is a revocable trust, the grantor at the time still maintains control of the property that's in the trust.
So if I have a revocable trust, I still control the revocable trust. I'm the grantor. I control it.
In an irrevocable trust, you are no longer in control of that property if it's drafted properly, right?
Right.
And one of the main situations, and I know you guys get this a lot, this question a lot from your clients. One of the main situations you use an irrevocable trust is to avoid Medicare nursing home fees, right? To take that asset that you're putting into the irrevocable trust and remove it from essentially what's considered your assets. By doing that, you're giving up control. So there is a very limited circumstance where an irrevocable trust makes sense, and that's where you're trying to protect assets, whether it be from a nursing home, from a creditor, and things like that, or protect maybe even from some type of lawsuit.
Yep, or estate planning toll when you're shifting assets outside of your estate because you're over estate planning limits. But just to use an analogy on that irrevocable trust, basically it would be if I created an irrevocable trust, I put my house and all my assets in there, and Brandon was the trustee of that account, right? So he can go sell my house while I'm living in it, sell all my assets off, legally,
Right.
We might have some issues,
Yeah,
but legally,
we're going to have to fight that in court. But legally, I think he has a good argument.
You got a good argument, right? So that's kind of the problem with these irrevocable trusts.
Yeah.
You know, they're more of a reactive toll than a proactive planning toll.
Exactly. And I think one of the issues that we always have to look at is that you have to do it so far in advance to actually get the protection. If you do it within a 5-year period, you guys know that nursing homes are still going to be able to come after that and count that as an asset of yours. So it takes advanced planning, and you're also giving up a lot of control. So it's a very unique type of estate vehicle.
Yeah, and I think, because we don't like to talk about the bad, but I mean, some of our clients might say, hey, I don't trust my son or daughter to inherit this money right away. Like you said, maybe we only allow them to spend 5% of it or $5,000 a month. Well, part of that is with an irrevocable trust. I mean, you can put stipulations on it. Right. So, those are the reasons why you would use that. But Dave, we talk about this all the time. Like, let's say I buy a house, and just from a tax perspective, let's say I buy a house for $200,000 and it appreciates to $1 million. Well, if I have it in the revocable living trust, my kids are going to get the step up in cost basis. So they inherit it at $1 million, they sell it, there's really no tax on that, right? Well, if you put it into the irrevocable trust, now they inherit that cost basis. So there are some downsides to that. You can protect it a little bit more, but maybe the tax implications aren't worth it. So there are some downsides to it as well.
There's pros and cons to everything. As an estate planning tool for higher net worth individuals, sometimes it makes sense, sometimes it doesn't. As an asset protection tool, again, sometimes it does, sometimes it doesn't. Like we hear often, and Rick, we take care of these ones, so you might not get them as much. You might get them too. But we'll hear often, well, I'm just going to gift my children my house, right? So then it's protected. But the problem is, Brandon mentioned this earlier, if I bought the house for $200,000 and it's worth $1 million today, well, I go gift it for $1. Well, instead of them inheriting that with no taxes owed on that house because they did the gift and they gifted it for $1, well, now their cost basis is $1. They're selling it for $1 million, and we got $999,000 in taxes.
Yeah.
Right.
Unnecessarily.
Right.
Well, a lot of people put their kids on the deed of their house as well.
Which is the same thing.
Right.
And the other issue with that, I guess maybe it's probably outside the realm of this, but then you have liability issues, right?
Right.
Anyone that's on a deed, if they get sued and let's say insurance only covers X amount, they're able to come after those personal assets. So,
Or if they get a divorce as well.
if they get a divorce,
Yeah.
right? So there's a lot
Yeah.
of kind of liability concerns that come
Yeah.
with that as well.
Yep. No, that's really important. That's a good topic. I think that kind of brings us, because a lot of this and what we're talking about today is we don't, and this Brandon and I deal with this every day. We don't know what you should do because
Right.
but having an estate plan is critical to how your assets are going to be distributed, and also there's a lot of protection pieces that come in on the front end. So we hear it often. Hey, I have a will, but I haven't updated it for 10 years, or I have a power of attorney, but it's never been executed, or things like that. So how often should families be updating their estate plan?
Yeah, we recommend to look at it every 3 to 5 years, right, at minimum. So that's a big thing. What we've done kind of at our firm, what I've kind of what I've wanted to do is look at major life changes as well. Tell the clients, look, if there's a major life change out there, you need to give us a call.
Yep.
We can't control that. What we also do is we look at the law. A lot of trusts that were drafted in the early 2000s and even the mid 2000s and the teens are no longer probably appropriate given the Retirement Secure Act, right?
Yep.
That was passed in President Trump's first term. That changed a lot of how we need to draft trusts, and you guys know what we should and should not put into trust, right?
Yep.
Yeah, so I guess for anybody who does have trusts listed as beneficiary, if they were drafted a while ago, maybe you do want to look at those.
Yeah.
And then maybe let's just talk about, should you name your trust as beneficiary of your IRA? Because we get that question almost every day. Should I just list my trust as beneficiary?
Right. It's give the attorney answer
Yeah.
again, right? That's going to
Yeah.
depend on your specific situation. One of the concerns now since the new act was passed in, was it 2017 or 18, I
I think in
believe?
2020 Secure Act.
Secure Act, okay.
Yep.
One of the concerns we have now is these required minimum distributions and who is an eligible designated beneficiary,
Right,
et cetera. And we really have to, it's a very complicated process now. I mean, it's almost like you're sitting down trying to solve a math problem. It does make sense in certain situations to name the trust as a contingent beneficiary, a beneficiary of your IRA account. If you come from a blended family, we've talked about that already.
Yep.
That's one. If we're concerned with beneficiary spending habits, possible addiction issues, things like that, where we really want to limit what they're entitled to almost immediately, we want to look at putting the IRA or putting the trust as a beneficiary of the IRA account. But again, it doesn't make sense all the time anymore. It used to, not as much anymore. So, and then, kind of getting into that, now the trust has to qualify to get those benefits.
Yeah.
The trust has to qualify under the IRS code, which is a whole nother kind of complicated situation.
Yep.
I'm sure we'll touch on a little bit here now, but that's where it kind of gets complicated.
Well, the problem is if it's just a trust and it's not written properly, like on your TOD account or your joint account, that's fine. You could have a trust, you could put whatever you need, but because of the Secure Act, if you name a trust as the beneficiary and it's not written correctly, that's considered a non-natural owner, correct? And all the taxes have to be paid as soon as it's inherited.
Mm-hmm.
Where if it's written properly, it could fall under the Secure Act, which is a 10-year distribution schedule, so you could stretch the tax out over 10 years. Used to be a lifetime, used to be a lot easier to do this.
Right.
Now, I know you know how to do it, but a lot of people don't understand how complex that new law has made it.
Right. And what you don't want is to have a improperly drafted trust thinking that your beneficiaries are protected. And then a few years after you pass, that your beneficiaries get a nasty letter from the IRS saying that they owe taxes on what they've withdrawn thus far, and they thought that they wouldn't have to.
Yep.
Yeah.
And that's a pretty bad situation to be in.
Yeah. And I'd say for most people, they trust their kids.
Mhm.
It's okay for them to just pass the money on to their kids. They have no issue there. So maybe it just makes sense to name them as beneficiary on the IRAs.
Yeah.
Right? Because that account, it's going to follow those same rules.
Mhm.
But for, maybe a TOD account or a joint account or your house, like those are the accounts that we really start to look at for trust planning, unless it's circumstantial, like you said. So.
Exactly, and that's done on a case-by-case basis. And it doesn't take just a meeting with an attorney. It takes the folks at Capital A.
Yeah.
It takes Brett Ches from Capital A Tax Planning,
Mm-hmm.
because it is that niche area of law where you really have to have all the appropriate folks kind of rowing in the same direction.
Yeah, you got to have some merit behind it to do that and kind of put those pieces in place on the non-qualified assets. Your TOD, your joint, those are a lot easier than doing it on qualified assets.
Yeah.
So maybe let's talk about kind of the last thing we have here. What are the risks of naming minor children directly?
Like in an IRA account.
Yeah, correct.
Well, first of all, that the problem is I know what I was like at 18, which you guys were probably like at 18, right? and those accounts, as we mentioned before, those are significant usually, right?
Yeah.
Those are the accounts where there could be a significant amount of money coming to them, and 18-year-olds tend not to listen to the experts all the time, right?
Right.
At least I didn't. And if you name them directly, they're essentially entitled to that immediately if they want it.
The entire account.
And they could tell Brandon and Dave, we appreciate you with everything you did for our parents, but thank you. We want everything up front
Where's
now.
my check? Where's my check?
And so it gets back to that point where, maybe they spend all that money now, right? And then the next year I had to pay taxes on that. That knocked
Right.
me into another tax bracket.
Right.
And that's where the real concern therein lies. And that's why it is so important to have those discussions with your clients to make sure they understand what's possible if they name their minor children. That document. And I guess one thing I do want to point out, kind of that we didn't discuss here, is with the revocable document, the revocable trust, we can always change it and update it too.
Mm-hmm.
That's one good thing about the flexibility it has. And that comes into play a lot here. We may have an IRA or a trust named as a contingent beneficiary of an IRA account because we have minor children. Well, in 15, 20 years, the circumstances change.
Right.
Maybe they start to listen a little bit more or are more cautious of what they
Right.
spend. It may make sense then to move that back into just a regular designation rather than having the trust.
Definitely.
That's a good point, because you could have a trust set up and your beneficiary can be the trust.
Mhm.
And let's say 10 years go by and you don't want your assets to go through that trust anymore. You just want it to go direct.
Right.
But you just eliminate the trust as the beneficiary and just change it to your children. It's a simple change.
Right.
The cost to set it up, yes, it costs money to establish it, but that most people will get from that. I'm a big fan of trust and using them, especially in PA. Ohio, we have an office in Ohio. I know you do a lot of planning for us in Ohio. We do a lot. Just for your home, for instance, in Ohio, you could TOD your home.
Yeah.
So you could do what's called a transfer of death. You still get the step up. In Pennsylvania, you cannot do that.
No.
So most homes in PA are passed through probate, and they can be avoided by having a trust.
Right.
So to me, those kind of things make a lot of sense for most of the families that we serve.
Yeah.
Absolutely.
You're paying up front for something that's going to give you to know that it's done right on the back end.
Yes.
I mean, what are you willing to pay for that, right? And
Yeah.
the attorney fees, Rick, it's worth so much more than what you're paying up front because you know that it's done the right way on the back end.
Right. And with a revocable trust, again, you could always change that. And circumstances change. So you might draft a will and, you have to change it 5 times. Well, by the time you change it 5 times, you paid 3 times what you would have for just a revocable trust with some amendments. And it gives you that flexibility. And I think that's a big tool to have. And one other thing with regard to that, I know a lot of your clients have property outside of Pennsylvania, right?
Mhm.
own a house in Pennsylvania, own a condo in Florida, South Carolina. Well, if you do that, if you own property in 2 different states, if you don't have a trust, you have to go through probate in both of those states.
Right.
That's when it really adds up.
Never thought about that.
Right. So you need to have a trust where it just goes through the trust rather than having to go through probate in a Pennsylvania and Florida. And I could assure you Florida's probate process is a lot more cumbersome.
I'm sure.
Yeah.
No, it makes a lot of sense. I mean, kind of just thinking through this, I think we said this a couple times, but it's very important to have a team working together, right? Because if you don't, you have an estate planning attorney drafting documents. Maybe the advisor doesn't even know sometimes that those documents are drafted.
Yep.
So they're not titling or funding that trust.
Yeah.
And then you have a CPA who has no idea what's going on, right? They're just filing the tax return. So I just think it's so important to have a team working together, for a lot of our clients.
Oh, I agree. Our mutual clients are so much better off, in my opinion, because of the work that we do together subsequent to their lifetime for their beneficiaries. If you don't have all that moving forward, that becomes a little bit tougher for them.
No, I agree. I mean, we've come across it where it seems like sometimes, like we're talking about the coordinated approach and how beneficial it is for these people, but sometimes it's like you get the estate planning attorney over here, you get the advisor over here, the CPA over here, and nobody's communicating.
Right.
And it becomes the client's job to relay these messages from each of these parties, where with us, it's all integrated.
Exactly.
You know, if I need something from you for a client
Right.
with their permission,
Right.
I'm calling you and we're discussing it, and then I'm relaying the message back to
Right.
them rather than, attorney, client, us, attorney,
Tax.
CPA.
Yeah.
Yeah, it becomes messy when it's not all together.
Yeah. One of the things I would challenge the people listening, if you are listening and you have questions, one of the things I would bring it to our attention, right? Because we try our best to get as much information as we can from our clients, but sometimes they don't want to tell us that, maybe their son or daughter isn't down the right path.
Right.
And if that's the case, well, that changes a lot of the situation.
Right.
And so I just think it's having those conversations, telling us what you're most concerned about when it comes to estate planning and protecting your assets, not just now when you're alive, but also when you pass. So, and that really helps us draft the documents that we need to. So.
Yeah, exactly.
Rick, I know we're going to kind of wrap it up, but is there anything that we missed that you feel like we should add? I mean, I know there's a couple other documents we didn't discuss, like power of attorney or healthcare power of attorney. Do you want to hit on those, and then we could kind of tie any loose ends up?
Yeah, I can hit on those briefly. So financial power of attorney is basically, and I'll put it in layman's term, is a document that decides who's going to make financial decisions for you in the event that you're not capable of making them and you're still living. So you're incapacitated. It's a very important document, and you don't realize you need it sometimes until it's too late.
Yeah.
Yep.
And so then your children or whoever is closest to you is trying to pay bills and trying to do things to help your situation, and they can't do it because banks won't work with them because there's no financial power of attorney. So, that's a big thing. And I guess along those lines is healthcare power of attorney, who's going to make those healthcare decisions for you in the event that you're not able to.
Yep.
A lot of people kind of don't affiliate that with estate planning, and it is, and it's an important part of estate planning because it does matter what happens during your lifetime that'll affect what happens afterwards.
I agree. Even on the financial power of attorney, Brandon and I talk about this a lot. So if you have an IRA, an IRA is an individual retirement account. So let's say me and Jacqueline are married, I have an IRA. If something happens to me and I can't contact my financial advisor, and she calls and says, hey, I need money out of Dave's account to pay these medical bills, but he can't talk to you. Well, legally, we are not allowed to execute that transaction because it is an individual retirement account.
Exactly.
So that financial power of attorney becomes really valuable, even obviously for children, but for husband and wives too.
Oh, without a doubt. You need, and again, most husband and wives, they're going to name each other as
Correct.
financial power of attorney.
Yeah.
But it's probably even more so important when that surviving spouse, I'll say, doesn't pass away, but is incapacitated. That becomes a big problem because there aren't really joint accounts with your children more often than not.
No.
And so, what you need to do is plan now for those unfortunate events to save headaches down the road. And those are the foundational documents, right? Your revocable will or your revocable trust, your living will, your healthcare power of attorney, your last will and testament, financial power of attorney. Everybody should have those or some combination of them, right?
Yeah, and if you need a trust, then there's more planning involved. There's reasons why you have those documents. So, no, that's great. I guess Rick, if there's nothing else you want to add, I know we could go down a rabbit hole for hours.
I don't think the clients want to hear me for another 2 hours on this stuff.
No, but we appreciate it. And if for the listeners, if you do have estate planning questions, Rick's a valuable resource. We definitely appreciate it, Rick.
I appreciate it.
We'll drop your contact info in the email that goes out if you're okay with that, and we'll get it out to everybody.
Absolutely. I appreciate you guys and most importantly what you're doing for your clients. It's great. Again, it's important to have everything rowing in the right direction. You guys know that. So appreciate it. Thanks,
Appreciate
guys.
you coming on.
Yep.